Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Professor Patricia Kane from Santa Clara University School of Law. And I'm just going to call her Pat.
Good.
Anyway, she's been teaching law for over 38 years.
Is it that long?
Oh my gosh, no. Must be somebody else. Anyway, she briefly practiced law before she became a professor, member of the Texas and Iowa bars. She provides consulting services to law firms. Patricia is a frequent speaker relating to tax planning for same-sex couples and has written many law review articles on that subject. And today, we're going to be talking about federal tax developments for same-sex couples after the recent federal Supreme Court decisions. Related to this, I want to share with you today's date is July 23rd, 2013. And one of the reasons we're doing that is we've got a moving target here. So the IRS we're waiting for them to issue some guidance. They've told us they will soon. We'll see how soon is
Whatever
soon.
that means.
Anyway, about how it's going to be administering the changes in the tax laws resulting from these decisions. And as we get into this also, I want to give a caution, as I usually do, that we're discussing issues in a very complex area. And this is a starting point for a bigger discussion. You should get qualified legal and tax advice. And also remember that, and as we're going to be focusing on here, that the issues that this revolves around relate to state law. And they are different from state to state, even if they, for example, we have an acceptance of same-sex couples as married for a particular state. For example, in California, we have our own peculiar brand of community property. And other states may have separate property and so forth. So anyway, you definitely need to get help from your local advisors. Pat, thanks for joining me here today.
Thank you for having me.
It's really, in some ways, kind of an exciting time because even as a person that, I'm not heavily into this, but nonetheless, just because when you've got a lot of changes going on, it certainly makes things interesting. So why don't you maybe highlight a little bit for us about what's happened here in the last month or so.
Okay. On June 26th, actually, the Supreme Court of the United States handed down two cases that are very important and that we've all been keeping an eye on in the lesbian and gay community and also in the tax community. The first one is the Windsor case. That is a case that is a tax case. Edie Windsor, as the administrator of her deceased spouse's, same-sex spouse's estate, was forced to pay an estate tax. And the death was back in the days before the 5.25 million exemption. So
Right.
She ended up paying a little over $360,000, and she thought it was unfair. She and her partner of many, many years had been married in Canada. Mm-hmm. They lived in New York. New York recognized Canadian marriages at that time. It's before New York enacted its own marriage laws. Mm-hmm. But they did recognize the marriage. And so she sued the federal government for a tax refund. She wanted her $360,000 back. The trial court ruled in her favor. The Court of Appeals ruled in her favor. And cert was granted at the Supreme Court level. There was some fear about this case because by this time the President and the Attorney General had both agreed that the Defense of Marriage Act was unconstitutional. It's basically said that for federal tax purposes, and in fact for all federal purposes, the federal government will not recognize any marriage unless it's an opposite-sex marriage. So the federal government did not recognize her marriage. And the AG decided not to defend the Defense of Marriage Act, DOMA.
The Attorney General.
The Attorney General. And so the Department of Justice generally does defend the commissioner in these cases. And instead, a special committee from the House of Representatives, the Bipartisan Legal Advisory Group, stepped in to defend DOMA. There was an argument that they didn't have standing. There was an argument that the Supreme Court did not have jurisdiction in the case because the government actually agreed with Edie Windsor, so there was no true case or controversy to be determined. But of course, she hadn't gotten her refund yet, so there was a real case or controversy. And in a 5-4 decision, the Supreme Court ruled that the Defense of Marriage Act is unconstitutional. That means it is unconstitutional today. It was unconstitutional yesterday, last year, and the year before. Such opinions typically have retroactive effect.
Yes.
So that means that for federal tax purposes now, people who are in same-sex marriages, at least in recognition states, because those were the facts in Windsor, will have their marriages recognized. On the same day, there was a case from California involving the constitutionality of Proposition 8. Now, this is a little different because it reached the Supreme Court after the district court had struck Proposition 8 down as unconstitutional under the federal Constitution, and the Court of Appeals for the Ninth Circuit had ruled the same way on a little bit different grounds, but had ruled also that Prop 8 was unconstitutional. Just like with the federal government, the state government did not want to defend Proposition 8. Governor Brown and the Attorney General refused to defend it. So in that case, it was the proponents of Prop 8. Now, these are private parties. These are not elected officials of any sort. They intervened and asked to be able to defend Proposition 8. Ninth Circuit wasn't sure whether they had standing, so they asked the Supreme Court of California whether whether Proposition 8 proponents had standing to pursue the litigation. And the California Supreme Court said, well, under state law they do, but this is now in federal court, so the state law ruling doesn't necessarily matter. And the Supreme Court, in another 5-4 decision, ducked the question on the merits and ruled that the Proposition 8 proponents did not have standing, therefore the case was improperly before the Supreme Court. It was also improperly before the Ninth Circuit. That leaves the district court opinion standing, and no one's quite sure what the reach of that is. Now, Governor Brown issued an edict, more or less, telling county clerks to start issuing marriage licenses. They started doing so right away, but the proponents of Prop 8 did not give up. They are now back before the California Supreme Court, and they've been joined by a clerk from San Diego who does not want to issue same-sex marriage licenses, and they're asking the Supreme Court to halt the order ordering clerks to issue marriage licenses. Now, initially, just a week or so ago, the California Supreme Court denied the injunction that the Prop 8 people had requested, although the case is still there to be considered on the merits. The question under state law is, does Governor Brown have the authority to order these county clerks to issue marriage licenses?
Right. So I think
pretty complicated.
I think what they were saying was, or the claim is, that this ruling only was effective for the two people who had brought the suit.
That's essentially